you opened up operations in Oregon as well, and have seen your hemp practice kind of mature alongside what the evolution of the market has been, and that's one of the things I want to talk about and hint on today. This regulation that is yet to come, how has it shaped the business that you've formed in Oregon, and how do you believe it's going to shape it in the future?
It's a little bit tricky because the states generally have implemented their own rules, thus far governing the amount of THC that they consider to be qualify as hemp. And Oregon is a little bit more loose with its regulations. So in Oregon, they just look at they don't look at the total THC. The total THC is something the USDA is using to determine whether it's hemp or marijuana. So anything over that 0.3 limit, really over 0.5, they're giving you a little bit of leeway, is going to be considered hot, what they called hot. And so that sort of kicks it over into the marijuana side. It's now in the jurisdiction of the DEA. There are a lot of people, including my operation, that have genetics that we're currently working with. They're sort of teetering on the line of hot. And so now there are a lot of people are kicking up a lot of fuss with the way these regulations are written, because it's essentially going to render some of their product unsaleable. So that's just one of several issues. There's a lot more science that needs to be there's a lot more that needs to be differentiated between hemp and marijuana, not just the THC, which right now is the only differentiating factor. The THC is what they're using to distinguish the two, and they are genetically very similar plants, but we don't yet know if there are any genetic differences between the hemp and the marijuana that we could determine. That's a better determination factor than the THC, which then obviously implicates the regulatory and potentially criminal implications. So there's a lot of stuff to look at, and I don't quite know that we're advanced enough yet with our research to be able to determine the two. But it's affecting a lot of people on the West Coast, particularly because those genetics run pretty hot.
That's a good point. We're finding that in our scientific research, you actually need a little bit of THC to allow CBD to do its full job, the CB2 receptor, right? And so that entourage or full broad spectrum and the entourage effect that's necessary for a lot of these compounds to be truly effective. We don't want to sell products with lack of efficacy, right? So when it comes down to consuming possible THC hot products, coming back here to Florida a little bit, let's talk about a little bit of the liabilities that some of our patients are facing if they are. And, let's talk about employers for a second. Do you think it's ethical or feasible for employers to stop, or hiring or be, I guess, prejudiced against those that are consuming CBD?
Yeah, there's a confusion that's going to happen in the market because of the distinctions between marijuana and medical marijuana, which you can use if you're a qualified patient in the state of Florida with a valid recommendation from a licensed physician, versus what you're utilizing day by day that you can order offline or get in certain stores that are hemp-derived CBD products. Now, most people assume if they have a hemp-derived CBD product that they are going to be fine when it comes to employers or any employment issues if you have a drug-free workplace policy. But the fact is that might not necessarily be true. There are some reports that CBD products are not properly labeled with the amount of THC that is actually in them, and then questions arise that if you use CBD products on a day-by-day basis and there is even 0.3% or less THC in it, could you possibly fail a drug test? I've had those in the drug testing industry say, yes, you could, depending on the testing that's done. And so you may have somebody who is using CBD products, not realizing that there could be THC, even if it is the legal limits of THC in a hemp CBD product, and now they're failing a drug test, and you're in the awkward position of convincing your employer you're not smoking marijuana or using marijuana products, but that you're utilizing hemp CBD products in compliance with applicable regulations. And it's even difficult for those who are patients in the state of Florida in the medical marijuana industry, because Florida has very broad protections for employers and not for employees. And our statutory law specifically carves out that you do not have a case for wrongful discrimination, for wrongful employment or discrimination if you are fired by a company that has a drug-free workplace policy, even if you are utilizing medical marijuana, again, in compliance with applicable state laws here in Florida. Not all states are like that, but you should take into consideration whether or not your employer is defaulting to those broad protections or whether they are going to make any type of accommodations if you are a medical marijuana patient in the state of Florida.
I see. Oh, go for it, Mike.
And I'm sorry, just because we've been involved in multiple different issues here.
Mike,
in
can
the
you
state.
move your mic?
Yeah. We currently have a couple different lawsuits in the state regarding employee issues here in Florida. We do believe that there's a conflict between the statute and our constitutional amendment. There is actually some positive case law out of other states protecting employee rights. And so, and our basis is this, our amendment, just like everyone that is in Florida knows that, 6 months ago, we didn't have smokable flower here in the state. That lawsuit went forward and was won on the basis of our amendment states that they're not required to accommodate on-site smoking, on-site public use of smoking, and that was part of the lawsuit. That lawsuit didn't deal with it, but our language is the same for employers. So what our amendment says is that they're not required to accommodate on-site use by employers. So there's a court out of Massachusetts that has held that required or meant that they were required to provide or accommodate, because accommodate is a term of art in the legal community to mean assist or make appropriations for people with disabilities for off-site use. And so that's the argument that we're using here in Florida for those. I do think our statute as well is consistent, as it does as well say, specifies on-site use in their definitions. So, and it's kind of like, if you're saying one thing, then that means the other or the opposite is implied. And so that's the argument. We are suing Nova Southeastern University, my alma mater. They kicked out a nursing student, expelled her for testing positive as a medical marijuana patient. Our medical marijuana patients does say you're not subject to any civil liability, criminal liability, or sanctions from complying with these sections. So on that Florida level, I think we are still trying to litigate that. Almost every state in the country that this has been an issue that it hasn't been specified, and even those states like Connecticut where there was specifications as to protections for employees, employers are still, just like they're doing in this state, well, the federal government says it's illegal, so therefore I can't allow it. The federal case out of Connecticut is great because the judge says, listen, the drug-free workplace does not require people to drug test at all. It just says if you do and they test positive, you have to provide these certain procedures. We're also trying to correlate our recommendation here in the state. In states like Oregon, I believe in California, the courts have said that their certification is akin to a prescription in that state. So under our drug-free workplace protections already in Florida, if you're on oxycodone or other legally prescribed medication versus a recommended certification, you can usually take a drug test as long as you're not under the influence of work and it's affecting your ability to complete your job, and you test positive for opiates or Xanax or anything, and you show them the script, that drug company will usually then show it as a negative because it is, because you're recommended or prescribed it medically legal. The Drug-Free Workplace Act, especially with hemp, I think already provides protections for this as well, because it also states, or other recommended doctor or legal federal or state level that's signed over the counter as a non-prescription drug. One case we were involved in was in Natural Life. They're here, they sold the products. It's a full THC spectrum oil, and I think that's the big difference for employees as well. If you're using an isolate, I think there's much less chance of you testing positive versus a full spectrum, which obviously has that THC in there. But it was, he was a corrections officer, and we came up and we testified on his behalf about the hemp issue. And I don't know how that resolved, but these cases are happening all the time, and especially with hiring of employees as well. And there was just, I think in another state, a case filed against Walmart for not hiring someone because they test positive for cannabis. So these issues are out there, and honestly, I expect the only way it to be really resolved is to go to the Florida Supreme Court. We've seen that in Colorado, we've seen that in Arizona, we've seen that in Massachusetts, but we are fighting for those things, but we are in a gray area at this point, sorry.
And there's, just a note on that, and Kyle, you may have something to say about this too. There was a case, and you probably know which one I'm talking about. There's blowback from that as well, while you have this drug-free workplace that we're trying to implement and work with. It sort of leans upon proper labeling of the products, right? Because there was a case recent, I believe someone was terminated. It was a truck driver or something for having THC in a system. And, his claim was I was taking something that was claimed to be THC free, or it was potentially full spectrum, but under the limit. And that's where the mislabeling of the products comes in. Whose fault is it really? And, am I required to have a medical card for consuming CBD products? No, not necessarily. But if it has, above the limit and I don't know about it, where does that put me in? And especially if I lose my job or something, that has a negative effect. Consequentially, we're looking to the FDA for more assistance.
I think it just highlights a lack of case law on a lot of issues in the cannabis industry. I mean, California had Prop 215 back in 1996, started their medical cannabis program there. And yet if you look on a case law basis, there is not enough for a panel of lawyers to feel comfortable on certain issues, especially emerging industries and markets like Florida's. I mean, we still, even from 2014, there are issues that are not being resolved yet, and hopefully we're going to get clarity on some of these things for the sake of employers and employees throughout the state to say, look, this just got resolved. Maybe there's some ambiguity in that statutory language. It's been favorably resolved in favor of either the employer or the employee, so that the average person doesn't say, I'll risk it, I'll lose my job, because the average person is not going to be able to wager on hiring lawyers to come resolve these types of issues for you. You're terminated for failing a drug test. I mean, that makes it very difficult for you moving forward. And so most people will just err on the side of not wanting to use maybe CBD products or not wanting to be a registered patient, even if it is the best medical product that they could be taking.
With that being said, we've heard some talk from the USDA recently and some guidance. Why don't we go through a little bit of what the USDA's plans for the upcoming. Terry, you want to come over and take the mic?
Yeah, we thought it might be helpful just to breeze through a couple issues on the subject matters that each of us are experts in, and that way it can set the stage. Was anyone here in the prior panel that had to do with the USDA regulations or FDA regulations? So we don't want to repeat a lot of it. For those who weren't, the difference between hemp and marijuana under federal regulations pursuant to the 2018 Farm Bill is a distinction as to whether or not the crop has 0.3% THC or less by dry weight. Vanessa's going to be able to talk a little bit more about the actual distinctions in the plants on a more specific level. But the way those regulations were written, and if you haven't seen the interim final rules, by the way, I talk really fast so I don't slow down, but the way that the interim final rules are written that came out on October 29th that were effective on the 31st of October and will be effective through November 1st, 2021, is that there is now going to be an open comment period as to those interim final rules, and states are going to have to bring their regulations in line with what the USDA is proposing. State, territorial, or tribal hemp plans must be approved by the USDA. There's a 60-day first come, first served basis for those who submit their plans to the USDA. I assume that Florida's regulations, because we are likely going to be stricter than what the USDA has proposed, should get approved pretty rapidly, but you never know when you send something to the federal government to review. The USDA plans will govern states, territories, and tribal lands that do not submit their own hemp plan, but keep in mind that states and tribes can still prohibit the production of hemp. So just because it is legal under the 2018 Farm Bill does not mean that states like Idaho are probably going to allow for the production of hemp. So we are going to see pushback in some states that are not going to allow it, but even if they don't allow it, they cannot prohibit the interstate transportation of that product. In addition, like I said, state laws can be more stringent than what the USDA puts into their regulations, and the interim final rules don't cover everything, right? So they are predominantly about cultivation and the regulations around cultivation, but they don't cover CBD, and Kyle will talk a little bit about this. This still remains the jurisdiction of the FDA. So people are like, oh, I've got these hemp plants, so I'm just going to say that hemp CBD products cure cancer and Alzheimer's and dementia and basically everything else under the sun that's a medical ailment. And that's pretty problematic from a perspective of FDA regulations. In addition, it does not provide federal banking guidance. So there are still banks and regulators. One, we've had regulators say that hemp is illegal, which was shocking. And then you're like, I'd like to redirect you to the U.S. government's website where you can easily learn that hemp is no longer illegal under the 2018 Farm Bill. And they say, well, it's high-risk clients, so we don't want to deal deal with high-risk clients, so we are not going to bank the hemp industry. So something to keep into consideration is that just because it is federally legal doesn't mean that every bank or financial institution is going to take on the hemp industry as a client. In addition, it does not help establish any federal seed certification programs. If you read the regulations in Florida right now, it says that certified seeds are the only ones that you can use to cultivate unless you get your seeds from a university or pilot program in the state of Florida. So whether or not pilot programs are actually going to be doing certified seeds is to be determined, but seed certification is a definition that is very limited, and there are no certified hemp seeds right now under Florida's stringent definition. That definition comes from Senate Bill 1020, which means the rules being promulgated right now that have to come in line with the USDA's rules can't even correct that issue because we have to comply with what Senate Bill 1020 set out, and Senate Bill 1020 in Florida specifically gave a definition of certified seed. In addition, it does not provide any leeway in allowing those who have been convicted of a federal drug felony from participating in the hemp industry. This is the state of the U.S. hemp. This shows you a lot of the states that have different programs, whether those are commercial programs or pilot programs. I think you're going to see a lot of changes in the coming months with the way that that map breaks down. When it comes to statistics on this industry, if you've read through the 161 pages of the interim final rules or you want some good bedtime reading, go ahead and go towards the end of those rules because the USDA did put out statistics on the industry that are worth noting. The first, over 77,000 acres planted between 2017 to 2018, projected to at least double in 2019, so we'll know those statistics by the end of this year. 817 producer licenses in 2016. From 2017 to 2018, that reached over 3,500. I think that we could have a few thousand people wanting to cultivate in Florida alone. And I think we're going to see a significant number of producers in Florida as well because we're a tax-friendly state for businesses. An estimated 2/3 of hemp acreage planted is used for floral material, while the remaining third is evenly divided between fiber and grain. If you want to see some good uses for fiber, look at Peter's shoes. Those are hemp shoes. The range of estimated revenues for producers of hemp product, it's a shameless plug. I should get a commission off stuff like that. The range of estimated revenues for producers of hemp products ranges from about $2,400 an acre to over $25,000. So you can see when you get that higher range, that's why a lot of farmers are saying, why am I planting peppers and making $300 an acre? I hear people are making $25,000 an acre. And we want to be realistic because the more people coming into the market, we can already see the trends that the cost is coming down on everything basically except for seeds nationwide. In addition, there's also a weighted variable cost of about $19,000 to produce 1 acre of hemp. Now, I think Vanessa can talk in more specifics about that as well, but those are some astronomical input costs for folks to take into consideration if they want to be a hemp farmer. And returns for individual growers can vary. They may even be in the negative, meaning you could lose money if you become a cultivator, which people need to also understand. It's a risky operation like any agricultural endeavor. You could grow something, you could grow nothing, or you could grow a whole crop full of marijuana and have to destroy it. Sampling costs on average for 24 acres range between $600 to $830, so sampling costs can be very high as well. And there's estimated increases in the revenue that's coming from this industry. If you project out to 2022, about $104 million, I think that's actually probably going to be on the low end. Under Senate Bill 1020, that decriminalized hemp CBD in Florida. So once rules are adopted, then growers are going to be able to apply for permits, and CBD producers and retailers will understand what that regulatory framework is and will have to come into compliance once those rules are adopted. CBD products in Florida have to have a COA, which is contemplated under our interim draft rules. It talks about how a testing laboratory must give you that COA that states the hemp extract is a product of a batch tested by an independent testing lab. Under the USDA rules, that has to be not only an ISO certified lab, but also a DEA registered lab, which severely restricts the number of labs that we may have available for testing in the state of Florida. I believe there's 1, which means we'll have a huge bottleneck if that's actually the case when cultivation licenses come about and people are ready to harvest. The batch has to contain a total THC concentration that doesn't exceed 0.3% by dry weight, and Florida is using the calculation of not only measuring THC, but THCA, which is the acidic precursor to THC, as part of that calculation. In addition, under the USDA rules, there's a measure of uncertainty that can be calculated by that independent testing lab. So it might not exactly be 0.3%, but if a measure of uncertainty, if you fall within that measure, you will not be hot under those regulations. And finally, the batch doesn't contain contaminants unsafe for human consumption. Moreover, CBD products distributed or sold has to have packaging that has that scannable QR code or a barcode, batch number, internet address of a website where information can be obtained about the batch, expiration date, number of milligrams of hemp extract. That's where we're seeing lawsuits right now, class action lawsuits against CBD companies for having a false advertisement of the amount of milligrams of CBD that they have in their products versus what is actually in there. Who thought that people were going to start testing their CBD at home and sending that off to an independent lab to see just how much was in there? That's probably some good lawyers behind that. A statement that the product contains a total THC of less than 0.3% or less by dry weight. So who regulates what in the state of Florida? Division of Plant Industry oversees cultivation. Division of Food Safety will oversee processing, manufacturing, and retailing of hemp and hemp extract. Act, and Division of Agriculture and Environmental Services will oversee issues related to seeds, fertilizer, and animal feed. And when can you grow hemp and where can you sell it? Well, hemp can be cultivated on lands that are primarily used currently for bona fide agricultural purposes or are zoned agricultural or industrial. Keep in mind that those rules do not contemplate what local governments can do from a zoning perspective when it comes to retail establishments, and you will likely see some pushback of local governments saying, we don't want CBD shops. They're going to put them in as head shops in their minds as well. So I've already heard some pushback from local governments, and I've also heard some pushback as well about the processing of hemp because of the secondary off-site impacts such as smell. So be considerate if you're looking for a processing facility of the way that local government regulations under their local development codes treat an industrial or manufacturing use if it has something to do with hemp. Finally, can you plant hemp now? No, not unless you're an approved pilot program. FDACS will announce when those permit applications are available. In addition, FDACS is going to have to complete our rulemaking before those cultivation licenses will be available. It is contemplated that we'll likely have those licenses available for the 2020 planting season, hopefully in January or February. And should you buy CBD from a gas station, I don't buy my wellness products from gas stations, but if you want to, feel free. But buyer beware, the CBD products currently sold in Florida, and this is straight from the FDACS website, are unregulated, untested, and without standards as to what consumers are putting in their body. That is not to say that all CBD products are untested or unregulated, right? There are some great CBD products out there that have COAs and great laboratories backing the types of products they're putting on the market. But there is not a state agency that is currently regulating and testing CBD products in the state of Florida, which is important for consumers to know. And that's because there have been reports of falsely advertised products with harmful additives or little or no CBD, and neither consumers nor FDACS can assure that what you have is completely safe for human consumption until rules come in place and until those retailers and providers have to go through our testing process to actually confirm it's safe for human consumption. And I can turn it over to Vanessa for some cultivation considerations.
Thank you, Tara. Wow, did you guys get all that? Any questions?
The first question will be, can you repeat that?
I know. Okay, so I'm not going to go through the specifics of the law so much, but these are some considerations from a cultivation standpoint, whether you're advising clients or whether you are looking to cultivate yourself or grow hemp or interested in it. These are just some things to consider. I'm sure you've gone over hemp and marijuana a little bit. We talked about the genetic differences between hemp and marijuana. They're pretty similar. They both fall under the cannabis sativa L genus, and they look the same, they smell the same. There's been a lot of law enforcement troubles in distinguishing what is what. So they are under the same genetic pool, basically pulling from the same genetic pool. They both contain over 100 cannabinoids, 2 of which are THC and CBD. So there's a potential for a whole lot more research, beneficial compounds that we could be pulling from these plants. The legislative bodies have determined the differentiator between the two to be the THC content. That's why we're looking at the 0.3 content as the distinguishing factor between what's considered to be marijuana and what's considered to be hemp. THC and CBD are relative, so the higher THC, the lower CBD content you're going to get predominantly. A lot of the hemp strains that we're seeing today are hybrids between, a hemp plant from way back when, one of your fibrous, stocky hemp plants, and some of the marijuana plants that you're familiar with. There's a photo here of a hemp plant. This is a pre-98 Bubba Kush, so this was bred by Dinafem out in Spain, and this is a cross between Bubba Kush, which is an indica strain marijuana, and one of the more stronger hemp strains. I can't recall which one. But you could see how similar the two look. So when you're buying genetics, and I stress this, I wanted to open with the difference between hemp and marijuana because you really need to be careful if you're going to select your genetics. Depending on what you get, you can easily go over that 0.3 limit, and then you're going to be stuck with hot hemp/marijuana. So you buy them traditionally in this three fashion in bulk seeds, which are unfeminized bulk seeds, so you basically don't know what you're getting. Buy them by the pound. Example, you could get a cherry wine strain, $3,500 a pound. There's about 20,000 seeds in there, and you put them all down, and it's at your risk. You're going to have to make sure that you got to pull all the males that are going to come out, and probably 50% of the seeds in that batch are going to be males. You want to work with the female seeds because the female seeds are flowered, and you want to work with the flower that has the highest content of the compounds in it and will not cross-pollinate your other your other crops and the other flower beneficial plants that you have. Feminized seeds are the better seeds to go, the better route to go. It's less risky. You usually buy those by the seed. Right now, you could get Bubba Kush seed for about $1 a seed, but they can run $1, $2, $3 a seed. So if you're planting this at like 1,500 to 3,000 plants an acre, you can see how just your startup stock is going to be really expensive. Now, the best way to go, if you were to ask me, is to buy clones or starts if you're just starting out. This guarantees that it's already germinated. If you see Florida's legal requirements of an 80% germination rate, that has to be on your certified seed that you're buying. But if you're buying clones or stock, obviously it's a plant already, so it's germinated. They're stronger and they're more apt to survive, so you've got less risk of loss there. The buyer knows the sex upon purchase. It's going to be a female plant, and you pay about $3 to $5 on the West Coast prices. The East Coast prices are probably going to be a little bit higher, and that also is going to depend on the genetic that you're buying. So what are you going to look for when you're purchasing a genetic? That's definitely, ad nauseum. We're going through that in the USDA regs and the Florida regs. Certificate of analysis, you're going to hear COA a lot. The COA, and this is for just some product. I think this is like an edible actually, but they look similar. So you're going to have the THC, which is the precursor compound content, and essentially it's looking for the LOQ. You want to be under LOQ, which is your limited or the amount of THC that is legal for you to have in the product. And if you fail the test, basically you have to destroy it pursuant to the Florida regs. A valid state hemp producer permit registration or license. So if you're buying some seed stock or plant stock from another seller or producer, you want to make sure that they have a valid permit or registration or license with that state that you're purchasing it from. Valid certificate of genetic material. So this is going to be the seed certification issue that Tara was talking about previously. We are getting into a little bit of, there are some states that have reciprocity in regards to seed certification. So if the state of Colorado certified a seed, California would say, okay, well, that's certified by the state of Colorado. We're going to consider that to be certified in this state. There's some question as to whether Florida is going to do that right now, but there are some legislative contradictions to that. So I would have to say we need to watch that. For crop planting, the things that you should advise or be aware of is budget, of course. There are a lot of costs that go into the front end of planting hemp, and you're dealing with a crop that is primarily, we don't have a lot of history and data in the state of Florida, so you better start out with 1 acre or 2 acres and sort of test that out and see how your strain is going to grow, where your region is. If you're higher than the middle of the state, you're subject to frost, then that's going to determine when you're going to plant. Most people want to plant in spring. You've got that longer day, but if you're in the state of Florida, sometimes it's better to plant in the fall and plant and grow throughout the winter. So budget accordingly. It's really expensive. It's very labor intensive. We talked about the potential for hermaphrodites or growing male plants. You want to have to walk the fields every single day and check the sex of your plants. They do have a tendency to seed out under stress, which could mean colder weather, warmer weather. And if you see those seeds, you're going to have people that know what they're looking for. You're going to have to pull those plants immediately because they can cross-pollinate and convert your other crop and essentially destroy your whole crop, turning it from female to male. So that's very labor-intensive, is also very expensive. You want to consider raised beds, drip irrigation, tape and plastic is probably one of the most expensive things. And then walking the fields, as the labor is relatively expensive. Pollen drift, you've got to keep in consideration, can reach for miles. So even if you're growing next to somebody, you have a tendency to care what your neighbor is doing. And this is a big issue out west with lawsuits. People are suing each other for cross-pollination of either their marijuana or the hemp crop, pollinating their marijuana. And the strains and genetics are sort of becoming muddled because everybody's growing next to each other. So we do in Florida care a lot about the invasive species. You've got the University of Florida that's working hard to make sure that we're doing everything that we can from a regulatory standpoint to protect the invasive nature of these plants. But as a farmer, you want to be sure that your site selection is probably far away from somebody else that may be growing hemp. and what you can do to sort of isolate yourself from cross-pollination. The CBD and THC content, they fluctuate constantly. And this is something that's very difficult for the labs and the tests that are done. I think that a prudent grower should be testing once a week. And once you get to that flowered stage, you really need to start testing once a week to see what your plant is doing. The consistency of the genetic, because you're probably going to be growing that strain over and over again, and then you can have a little bit of data built up as to what temperature outside, if it was humid, if it was less humid. But the stress is going to it's going to spike your THC content, or it's going to, it's just going to somehow affect your THC and CBD, and then you're going to be at risk for testing out of compliance and potentially destroying your crop. I wouldn't follow any SOPs that any other farmer gives you. Don't go online and print them out. You really need to sort of, I would say initially work with a consultant, probably from the West Coast, and that has worked with large-scale farms. We're not just growing 1 acre, and you can't just take that 1 acre data and then times it by 50. It becomes a very different game. So I would work with a consultant in the first year. I would definitely work with a genetic consultant, work with a lab consultant, somebody that understands the compounds. Another thing that's happening out west I see a lot is when you're growing it, you're great, you've done well, your flower's beautiful, you passed your test, now you're ready to harvest. You know how many people you need to harvest. You know what you're going to do with the material. I mean, I've seen it take, 1 acre can take up to 800 square feet of dry space alone. So if you have 50 acres or 100 acres, how are you drying this? And you have to be cautious there too, because the way that you dry your plant can really create a lot of mold or mildew and render your crop, which was viable, non-viable. So dry space and making sure that you maintain the climate control in that dry space is also just as important as genetic and strain selection and growing it. And then wet processing, and I'm not going to get too much into processing, that's a whole nother beast, but wet processing is around the corner, which helps us with the dry costs and the square feet and the warehouse space that you may need for drying. I'm not going to, but just keep that in mind, just to start look for wet processing, because it is around the corner, and that's going to help with the costs for, and the need for a lot of space for drying. But I'm going to pass this on to Kyle now that we're going to get to the more finished product. Thank you.
Thanks, Vanessa. Okay, I'm going to talk to you about FDA's considerations and how FDA has oversight and how that intertwines with USDA and also the state regulations that we've been talking about. So just sort of generally, who and what is FDA? FDA is obviously the United States Food and Drug Administration, and they regulate things like foods, drugs, biologics, which are vaccines, other living tissues, medical devices, cosmetics, veterinary products, and tobacco. So hemp itself can be both a FDA-regulated product, if you're talking about hemp as a food ingredient or dietary supplement, or it could be a product that is not FDA-regulated, like Peter's shoes, which are used for textile purposes or other non-food, like that.
You got the second.
I get a plug. So that's sort of the way you have to look through this. So hemp is going to be regulated by USDA, but it's only going to be regulated by FDA if you're using it in a food, a drug, a cosmetic. Veterinary products are becoming very popular. And so you really have to understand what is the mode that the hemp is going to be used through. CBD obviously is sort of the 800-pound gorilla in terms of hemp's use in FDA-regulated product space. We see CBD in everything, like we said, pet treats to you name it, and it's out there. I've seen it in mouthwash, all sorts of things. So what is FDA doing in terms of regulating CBD? I talked about this a little bit earlier, but FDA is currently saying that CBD is not a proper dietary supplement or food or dietary ingredient or food ingredient. And that's because CBD is the active pharmaceutical ingredient in Epidiolex, which is the drug we mentioned that is for certain children's seizures in children, FDA can, however, create an exception to the rule that says an active pharmaceutical ingredient cannot also be a food ingredient. And FDA is looking at doing that. That's one of the things that they're thinking about doing. The other alternative is Congress could act. Congress could essentially pass a law that amends what's known as the Federal Food, Drug, and Cosmetic Act, and that would actually be a much quicker fix, because if we're going to get CBD legal through FDA regulation, that's going to come with notice periods and comment periods and interim final rules and final rules, and it's going to be a much longer process than if Congress were to simply pass a law allowing CBD to be sold legally in foods and drinks. In the interim, FDA is engaging in what's known as enforcement discretion. And enforcement discretion is essentially a government policy that says, hey, I know what you're doing is not legal, but we're going to sort of disregard the illegality of it for the time being. But there are some exceptions to that, right? So what FDA is saying is that if you're a product that has what I call here unacceptable labeling and advertising, they're still going to come after you. Now, there's so many products on the market that it's not realistic that they're going to come after everybody, but FDA is certainly very active in looking at CBD products. They're looking at websites, they're doing inspections at facilities, and they're really going after what they call impermissible efficacy or drug claims. And that's things like saying, hey, this CBD product cures cancer, it treats diabetes, Alzheimer's, Parkinson's. Anything like that, FDA is very active in regulating. They've got an eye on it. They've said for the past year and continue to say that they're going to continue to regulate those products. And so if you're in the CBD space, you're looking to join the CBD space, some of the things you want to do is be aware of FDA's food and dietary supplement labeling regulations. They're generally the same for foods and dietary supplements with a few exceptions, but you've got to have the net weight of the product. You've got to have a statement of identity. For example, vitamin is the statement of identity. Quantity of contents, so 30 gummy bears. Nutrition and supplement labeling, which is, that's where it differs. For food, you have to have a nutrition facts panel. For dietary supplements, you have to have a supplement facts panel. And you have to have an ingredient listing, which is things like excipients or other parts of the product that are not intended to have an effect on the body. And again, there's lawsuits that we're seeing pop up as well for what we call these unacceptable labeling and advertising claims. So not just do you have to worry about FDA, but we've seen at least 5 lawsuits in the past 2 months that have been filed, primarily alleging that these CBD products have an understated CBD content and are therefore false and deceptive under certain state laws. And here's a couple examples of actual products that FDA has sent warning letters about. A warning letter is FDA's primary means of enforcement. They will go and inspect facilities, but they're understaffed, underfunded, and primarily they're going to go and look at websites, they're going to look at labels, and if they see something they don't like, they're going to send you a warning letter. When they send you a warning letter, you have a certain period of time to respond. If you don't respond or they're not happy with your response, they can take further action, including seizures, injunctions, shutting you down, monetary penalties, and even criminal prosecution if it continues. For example, this language at the bottom is for that product on the right. It's made by a company out of Florida called Rooted Apothecary. And they received an FDA warning letter, I think in October. And some of the claims that FDA said were impermissible were these claims about anxiety, neurological conditions, PTSD, anxiety, depression, cancer, diabetes. And what's important in this context is you don't see these claims on this label, but they're on the company's website. And FDA has very clearly said for many years that it views website claims as an extension of labeling. So just because it's not on your label, if you have it on your website, you're still subject to FDA enforcement, as well as FTC, the Federal Trade Commission, who also has dual enforcement over website labeling and advertising. Very quickly, let's talk a little bit about the current state patchwork of state regulations specific to CBD. This is a list I put together that seemingly changes weekly based on what the various states do. And this is not based on official legislation. It's based on everything from state enforcement discretion, state appetite for CBD, executive viewpoints from governors, for example, and enforcement by our law enforcement activities in those states. Other things to keep in mind is, in addition to complying with FDA regulations on labeling, certain states have labeling requirements as well. For example, Florida, Indiana, and Louisiana are all requiring QR codes on CBD products. And so you could have a CBD product that's perfectly legal to sell in Georgia under Georgia state law, setting aside FDA's position, and that may be illegal in Florida if it lacks certain labeling requirements. Some states require a specific statement. For example, Colorado requires a specific statement on every CBD product saying that it's not approved by FDA. Louisiana and Texas require a license. You have to get a license from the state in order to sell CBD. And some states like Kansas, for example, has a 0.0 THC content in it, which is the only state we currently see that doesn't follow the 0.3 percentage, but is sticking to a 0.0, which is not all that clear. Pass it back on,
Mike.
Peter and Michael.
Michael, you want to
Michael,
get up
wrap it
front?
up?
So consideration.
I guess I have a question for you. So, with the rules and regulations and the FDA Farm Bill only giving the states rights to regulate the production of hemp. So luckily, law enforcement has taken a step back at this point, and instead of arresting people first, they're trying to work through it, confiscating some of the material, and then either if they want to spend the money on getting it tested, they're getting it tested. We're seeing a lot of people not prosecuting on these issues right now. But these are all things, getting into this space you have to be aware of, and you have to really, I think spend the money on one of us to be able to make sure that you're compliant and you stay compliant. These things are changing, really on a daily basis, both in this state and across the country. And if you really want to succeed, I would say, one, start with the higher standards, and comply with the FDA regulations on food establishments and things of that nature. Because I think this will end up being like every other product. And I think the USD interim regs say that and say, for FDA rules, look at the current rules that they have in compliance on those issues to be using it. And just stay vigilant. This is going to be a huge industry here in the state, and it has enough room for everybody. Find your niche and get into it, because it's going to be exciting. We're going to be huge here.
Wow. With that said, we got to wrap this thing up. Mike will be available for questions at the bar later.
Just have to buy me a drink, cheap date.
And that's the cheapest retainer you're ever going to get. Thank you guys all for attending, and that's the end of our presentation for today.